I think in discussing these requirements for the subsistence of copyright, very briefly, is that firstly, your work or your subject matter must be a work, which generally means that it must be of sufficient substance for it to classify as one of the different types of works. There's been, some talk and consideration as to whether the title of a book or the title of a movie or song might be of sufficient substance to qualify as a work, and the general consensus is that it is not. So you would rather consider registering or protecting that title of a book, song or film as a trademark, whereas the content of the book, song or the film itself would be protected by copyright. So firstly, a work must be of sufficient substance. If you, for example, write a poem, you write a book, you make a painting, you develop a computer program, it must be of sufficient substance. Secondly, it must qualify as one of the works, which I've mentioned, being a literary work, an artistic work, a computer program, and so forth. And looking at the requirements for the subsistence of copyright, copyright will exist automatically if your work is firstly original, in the sense that, unfortunately the Copyright Act doesn't define what original means, so we've had to look at the judgments of our courts, the interpretations which have been given there to, which has generally been agreed that, a work will be considered to be original if it, firstly looking at what it doesn't necessarily have to be, it doesn't necessarily have to be new or inventive. A work will be original, if you can show that as the author, the creator of that work, you have used your own expertise, your own knowledge, effort, skill, whatever the situation may be in creating that work, and that you didn't copy it from any other third party's material. So basically the moment that you can say that, I've copied this work or I've copied a part thereof, then definitely the work in itself, or perhaps just a part thereof, will not be original. But a work can be partially original. The part of that work that will then be original is that the part that you can show you created yourself. The second requirement is that a work must generally be in a material form. The only two exceptions to that, and that's just as a result of the nature of the works, is that a broadcast and a program carrying signal need not be in a material form, but all the rest must be in a material form. There must be something tangible, whether it's been written down in black and white on a piece of paper, whether it's stored on a computer hard drive or some other storage device. It must be in a material form. The important aspect of this requirement is that there is no copyright that subsists in someone's ideas or a concept or a thought. It could be potentially that you can get protection in that the physical embodiment which you've given to that thought, concept or idea. So if you have a storyline which you're working on in your head, or you in the process of composing a song, but there's nothing tangible yet, then it will not be protected. It will, the protection will vest in what you have embodied into that material form. There are then another technical requirement, in fact two, the one works as an alternative to the other, and that really requires that the author of a work must also be a qualified person in terms of the Copyright Act. Now, a qualified person is luckily defined in the Copyright Act. It says that really any resident or citizen of South Africa, or any country to which the operation of our Act has been extended, which are all the Berne Convention countries throughout the world, will be a qualified person. A juristic person, such as a company or close corporation, can also be a qualified person, and similarly it would be a juristic person that conducts business or is registered in South Africa or any Berne Convention country.